5, 4, 3, 2, 1. Learned counsel for the petitioner submits that the accident took place on 6/4/2012, whereas the prosecution report was filed on 21/8/2012. She draws attention of the court to section 106 of the Factories Act and submits that in view of the said provision, the case was required to be filed within 3 months, whereas it has been filed on 29/8/2012, that is, after the said report. She further submits that even no petition for condoning the delay has been filed. On these grounds, she submits that entire criminal proceeding is bad in law. On the other hand, learned counsel for the state submits that the occurrence is there and that is why the report was filed and the learned court has taken cognizance. He submits that there is no illegality in the impugned order. In view of the above submissions of the learned counsel for the parties, the only question is required to be considered by this court in view of section 106 of the Factories Act, which prescribes the period of limitation for 3 months for filing the complaint under section 92 of the Factories Act from the date of occurrence. It is correct or not? It appears that the occurrence supposed to be taken place on 6/4/2012 and the prosecution report was filed on 29/8/2012. The company has already furnished the information under statutory form 17A. Thus, information was there to the factory inspector about the accident. For ready reference, section 106 of the Factories Act reads as under: limitation of prosecutions. No court shall take cognizance of any offence punishable under this act unless complaint thereof is made within 3 months of the date on which the alleged commission of the offence came to the knowledge of an inspector, provided that where the offence consists of disobeying a written order made by an inspector, complaint thereof may be made within 6 months of the date on which the offence is alleged to have been committed. In the case of a continuing offence, the period of limitation shall be computed with reference to every point of time during which the offence continues. Where for the performance of any act, time is granted or extended on an application made by the occupier or manager of a factory, the period of limitation shall be computed from the date on which the time so granted or extended expired. On perusal of the complaint petition, it is crystal clear that it was in the knowledge of the factory inspector that the occurrence took place on 6/4/2012 and the prosecution report was filed on 21/8/2012 and the cognizance under section 92 of the Factories Act was taken against the petitioner. On perusal of section 106 of the Factories Act as quoted herein above, it is also crystal clear that the law with regard to filing of the complaint under the Factories Act is within a period of 3 months from the date of commission of the offence or from the date of knowledge of the occurrence. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है।